Alright everyone, there's been a little bit of a victory over in California with regards to gun laws. Now, a lot of courts traditionally don't really touch the issue of whether it's constitutional or not for a state or for the federal government or whatever to ban certain accessories for firearms. For instance, Trump has implemented a de facto bump stock ban that I believe doesn't actually do anything. like it fell through. No other gun control really has gained traction in a long time. And in fact, we've seen a pattern since DC versus Heller and McDonald versus Chicago. A lot of gun laws locally and on state levels have been significantly relaxed, which could have something to do with why we have lower crime now, as criminals get killed, because criminals don't follow the law and prefer guns that aren't on these ban lists anyway. Like, criminals, they're not going to use a handgun that has like, oh, well, yeah, I invented this new 50-round magazine for it so that it's 2 fucking feet long, making it harder to actually conceal. It doesn't make any sense. Now criminals have to deal with the fact that people around them are actually well armed and they could be packing at any given time. Makes their job a little bit harder and a little more dangerous. Good, by the way. The victory is this. California's federal court has upheld an injunction that was issued by a lower court. California right now is battling a legal battle by people who are saying, hey, the law itself is unconstitutional. You can't ban these magazines. We're asking the court, by the way, to issue an injunction to prevent an infringement of people's Second Amendment rights while the case is waged. Lower court agreed with that sentiment. California said, well, that's balderdash, and appealed that to a federal court. Now their only place left to go would be to SCOTUS. What do we know about SCOTUS right now? It would definitely side with the claimants there. It wouldn't be siding with the state of California. The one problem with Californian legalism is they have to understand that if any case is appealed to a higher power that's not controlled by California itself, they will tend to lose because it's so ludicrous. The same would be true of Vermont. Vermont has such a magazine ban, which I think someone told me it doesn't take effect till October, so I guess stock up now on things that are not made retroactively illegal. Like, the law is toothless. It's just like Clinton's assault rifle ban. It didn't grandfather in existing weapons or peripheral items or anything. It just meant you can't make new ones. Well, all that means is that a lot more of them are sold beforehand. I mean, it's ridiculous. By the way, how are you going to make sure that it wasn't in the state to begin with? If it was manufactured in another state beforehand, and you bring it in, you're like, yeah, I've had it all along. It's immune to the ban. You can't ban it. So it's not going to do anything. It's totally fucking toothless. But this legalism is totally unconstitutional. I have a feeling that California will lose, and that's really good because a lot of courts have been reluctant to take such cases or to really weigh in on them and determine once and for all, yes or no, the government can ban expanded magazines. I say, of course, it's against the Second Amendment quite clearly. It's obvious that they don't have that right. And also, states are bound, at least for the most part, to the federal constitution. The state, for instance, a state can't say to you, there are certain things you're not allowed to say outside of the realm of what would be criminal anyway, like defamation or something. They can't say, for instance, that you're not allowed to say Guten Tag. They can't make a law against that. It would violate the First Amendment, despite the fact that the Constitution on the national level ostensibly relates to the federal government. However, it's been found the fundamental aspects of it also trickle down to the states. They have to be bound by it too. You know, if they had found opposite that, the liberals hated it at the time when that decision was made. If they had done the opposite, though, it would have allowed ultimately a bunch of red states to basically ignore equal protection. So, you know, they shouldn't have looked a gift horse in the mouth, I suppose. With California's restrictions, though, they're roughly the same as Vermont's that they're trying to impose in certain other states. So the hope is that this goes to SCOTUS. My hope is that Trump gets his next appointment to the Supreme Court, and Kavanaugh gets in there. You've got 5-4 people who tend to lean to the right. Then they take it before SCOTUS, and SCOTUS once and for all makes it clear to everybody under the sun within this country, yes, the Second Amendment protects bullets and magazines and things like that, which are necessary to actually utilize firearms. Because if you could ban, think of it this way, let's say that a state were to take up this line of reasoning. Well, we can't ban the AR-15. SCOTUS won't let us. But we can ban every magazine ever made so that you can't utilize the weapon. We can ban the ammo involved. We can ban pistol grip. We can ban bump stock. We can ban suppressor. We can ban anything that makes the gun fundamentally useful, because otherwise it will be little more than a piece of metal. It'll be a club, essentially. It won't be able to fire because there's no way to actually fucking get ammo to fire from it. People have to use like black powder weapons and stuff. If a state were to do that, wouldn't that be a little bit of a problem? SCOTUS would be, I think, keeping that in mind, and they'd say, well, ultimately it is a black and white scenario. Either there's a precedent for states being able to limit things, in which case they can limit them to an extreme and draconian degree, because within legalism you can't say, well, it's simply reasonable restrictions. That's not a constitutional argument. It's been the going status quo within courts for a long time because they're too cowardly to finally weigh in on the issue. But it is a black and white issue. The Constitution doesn't say, well, reasonable restrictions apply to these amendments. That's not what it says. There's no such thing as a reasonable restriction on gun rights. There's no such thing as a reasonable restriction on your right to privacy outside of the realm of properly issued warrants. Proper surveillance, again, involving the court, not a FISA court, not a rubber stamping court, an honest-to-goodness public court where you can have your day and you can go in and cross-examine and things like that. That's how a proper warrant's issued. We shouldn't have a police state at all. Gun control shouldn't even exist in this country. Gun control was originally predicated on a bunch of Southern Democrat Klansmen saying, oh, well, shit, now that the black people are free, now that they're citizens, they're going to have firearms. We've got to be able to prevent them from getting them. And so they made the argument, a bunch of liberals, a bunch of Democrats, people in the South wearing their robes and hoods. They were the ones that pushed the first gun control in this country. And since then, the Democrats have steadily stood for it. And that's basically where it comes from, the Jim Crow era. Look up the Cruikshank decision. It was the decision repealed by, I believe it was McDonald versus Chicago in that case. It might have been Heller versus DC. Sometimes I get those two mixed up a little bit. Two most important pieces of pro-gun legislation, which is basically what they amount to, because they stripped back a hell of a lot of legalism. And it is technically judicial activism. The thing is, it's overruling prior judicial activism and restoring the Constitution. The problem is that in the middle of the 1800s, we decided as a nation to start tempering the concept that people were free and that government could be benevolent, or that people should manipulate it for identity politics purposes. That's what Cruikshank essentially was. Hey, this small segment of the population scares us because, we had enslaved them. They might be a little bit angry. We don't want them to have firearms. Sorry, but it's not a constitutional right of the states to do so. The states fundamentally can't do that. I think that it's ridiculous that they would say, well, we have the right to impose reasonable restrictions on magazine size. What do you define as reasonable? A 1-round magazine? 2 rounds? What if I think 10 rounds is too much? Well, I shouldn't be able to be making that determination. Neither should you or anybody else. If someone wants to have a 100-round fucking drum on their AR-15, who fucking cares? Whose business is it? It's their business. Have they committed a crime using the weapon? If so, then that's a different story. Until they do something actually wrong, violate some legitimate law, they call off and shoot somebody, or they're endangering the public or being a nuisance by, firing their gun off constantly at midnight or something, until something like that happens, you should leave them alone. Because most of them are never going to shoot another human. In the majority of cases where they do, it's probably either themselves or an assailant that is legitimate to be shot. That's the truth about guns in this country. That's about all. Peace out.